Hold that plane ticket. If you are a U.S. green card holder planning any international travel in 2025, you must watch this video right now. The rules have changed. Border enforcement is tougher than ever, and a small mistake on your trip can lead to detention, removal proceedings, and the devastating loss of your permanent residency that I in the next few minutes. We're breaking down the critical new warnings you need to know. Don't let a vacation cost you your U.S. home. Stay tuned. This is your 2025 travel protection plan. The abandonment trap. The time rules that revoke your status. This is the most fundamental, yet most misunderstood rule. A green card requires you to maintain the U.S. as your permanent residence. The moment U.S. Customs and Border Protection, CBP, determines you have abandoned that residency, your green card status is forfeited. The length of your absence is the clearest signal of this intent, with an absence exceeding 6 months, 180 days, inviting intense scrutiny at reentry. Furthermore, continuous travel abroad for 1 year or more creates an automatic presumption of abandonment, invalidating your green card for return. To avoid this trap, you must consistently demonstrate strong ties to the U.S., proving your stay abroad was only temporary. The 6-month red flag. If you remain outside of the U.S. for more than 180 consecutive days, but less than 1 year, you trigger the first major red flag. While this absence alone doesn't revoke your green card, it creates a rebuttable presumption that you may have abandoned your U.S. ties. CBP officers are required to question you extensively about your trip, your reasons for the extended absence, and the documentation proving your permanent life in the U.S. Furthermore, an absence of 180 days or more breaks the continuous residency period required for U.S. You will have to restart the clock on that 5-year or 3-year residency requirement. The 1-year crisis. If you remain outside of the U.S. for 1 year or more without prior authorization, your green card, your Form I-551, is considered automatically invalid for reentry. You will be detained, refused admission, and placed into removal proceedings before an immigration judge, who then has the sole authority to determine if you truly abandoned your status. Your entire life in the U.S. can be put on hold, and you will likely require legal counsel immediately. If your travel will exceed 6 months, and especially if it will approach or exceed 1 year, you must apply for the reentry permit, Form I-131, before you leave the United States. This 2-year travel document proves your intent not to abandon your status. Crucially, you must be physically present in the U.S. to file the I-131 and attend your biometrics appointment. Failing to get this document for a long trip is the single biggest mistake an LPR can make. How to prove non-abandonment. Regardless of your trip length, if you are questioned, you must be prepared to pass the TICE test. You must carry physical and digital evidence showing that the U.S. is your true home. Current and past U.S. tax returns filed as a resident, active U.S. bank accounts, investments, and property tax payments. A lease agreement or home title in your name, utility bills, and an unexpired U.S. driver's license, including in physical ties. A letter from your U.S. employer confirming your employment is held. Proof of active enrollment in U.S. schools for your children, or maintenance of a U.S.-based professional license. The permanent risk of past criminal history. Many LPRs assume that once they get a green card, past legal issues are irrelevant. This is false. Every time you seek readmission, you are subject to the grounds of inadmissibility. Any conviction, arrest, or charge, no matter how old or how resolved, can be flagged. Crimes involving moral turpitude, certain drug offenses, or multiple minor convictions can make you inadmissible. A CBP officer can determine at the border that an old offense makes you inadmissible, even if you were previously admitted with that same history. They can detain you and immediately issue a notice to appear for removal proceedings. At the border, you do not have the right to an attorney during the initial inspection. We are seeing increased use of technology to cross-reference global travel and criminal databases. If you have any criminal history, you must consult an immigration attorney before you travel. Trying to hide or minimize the issue is a direct path to detention and removal. Digital scrutiny and the conduct rule. This is a major area of new risk that affects everyone, but especially LPRs. CBP officers have expanded authority to inspect your digital devices at the border. Your phone, laptop, and tablet. They're looking for evidence of intent and, critically, information that could fall under security or criminal grounds for inadmissibility. Before you travel, wipe your devices clean. Use a clean phone that contains only essential, professional, or benign information. Delete all sensitive messages, highly personal photos, and controversial political or religious content. Do not give them material to question you on. Conditional green card holders. To protect your immigration status, whether related to a marriage or an investment, it's essential to keep international trips short, ideally under 30 days, as lengthy absences can raise suspicion. If you have already filed your petition to remove conditions, Form I-751 or I-829, but are awaiting your interview, you must carry the official Form I-797 receipt notice. This document is vital because it acts as an extension of your expired green card validity, often for 48 months, and you may be denied boarding a flight without it. Finally, prioritize your immigration process. Do not miss your scheduled interview for any reason related to travel, as this will lead to the denial of your petition. The practical threat. If you are a national of a country placed on a banned list, your travel will be seen through an increased security lens. Your LPR status makes you one of the few individuals from that country able to travel freely, making you a target for secondary inspection. CBP officers will be searching for any reason, abandonment, an old misdemeanor, or a security affiliation, to challenge your status. If you are a national of a country subject to a ban, consider your international travel to be high risk. Your green card can be revoked if it is determined that you committed fraud or misrepresentation when applying for or maintaining your status line, or omitting crucial information, like a prior criminal record or deportation. On immigration forms, entering a marriage solely to obtain a green card by fraud is also a threat. The inspection process. Be prepared for secondary inspection, especially if your trip exceeded 6 months or you are a national of a high scrutiny country. Answer all questions truthfully, but be concise. Do not volunteer any information not explicitly asked for. A simple yes or no is often the best answer. You have the right to remain silent regarding questions about your immigration status. However, refusing to cooperate will almost certainly result in detention and referral to secondary inspection or immigration court. While U.S. citizens have strong protections against device searches, the rights of LPRs are significantly weaker at the border. Refusing a device search can result in your device being confiscated and your detention, while officers obtain further legal review. This is why device preparation wiping is critical. Never sign away your status. This is perhaps the most critical takeaway. In secondary inspection, an officer may press you to sign Form I-407, Record of Abandonment of Lawful Permanent Resident Status, in exchange for a quicker exit or promise of future travel back to the U.S. DO not signed Form I-407. Signing this document is a formal, voluntary, and often irreversible surrender of your green card. Once signed, you have legally abandoned your status and will need to start the entire immigrant visa process over if you wish to live in the U.S. again. If the officer insists you have abandoned your status, politely state, "I disagree. I maintain my permanent resident status and request a hearing before an immigration judge." Only an immigration judge, not a CBP officer, has the authority to formally strip you of your status against your will. So, to summarize the critical rules for 2025, do not stay outside the U.S. for more than 180 days without a plan. Always carry overwhelming proof of your U.S. ties, and never sign Form I-407 under any pressure. The goal here is to make you aware so you can travel safely and protect your status. If you have a criminal history, or if your trip will exceed 6 months, the single best action you can take is to consult with an experienced immigration attorney before you book your flight. If you found this information vital, please hit the like button, share this video with every green card holder you know, and subscribe for the latest, most urgent immigration updates.